A very warm welcome to everyone. My name is Matej Avbelj. I'm a professor of European law at the new university here in Ljubljana, Slovenia. I'm also a chairholder of the Jean Monnet chair dedicated to pluralism in the European Union. It is part of this Jean Monnet chair initiative to host European academic forums, that is, debates on various topics touching the usually theoretical, but also practical issues of European integration that reflect on or actually mirror its pluralist image. And today's debate will be dedicated to a discussion of two books which are touching on a very important constitutional issue, and that is the question of national constitutional identity in the European Union. I'm very pleased to have with us two great speakers, two great scholars, both also colleagues of mine. Both of them are somehow connected to Germany, but they are not really German scholars, as you will learn also from their presentation and also from their work. So we will have with us Kriszta Kovács, who's a professor who currently works at the WCB in Berlin, Wissenschaftszentrum Berlin, and who's also teaching at ELTE University. And she's the editor of a book entitled The Jurisprudence of Particularism, National Identity Claims in Central Europe. Kriszta, hi, thank you for being with us. And our second speaker is Julian Scholtes. He currently works as a lecturer at the University of Glasgow. And he's the author of a monograph entitled The Abuse of Constitutional Identity in the European Union. So when I was reflecting on how to structure this debate today, I was also thinking of which work is more important, or if not more important, which work is harder to produce. Is it a monograph or an edited volume? And I have to say the jury is still out, because if you're writing a monograph, then you just work on yourself. But if you're producing an edited volume, it's you yourself and other authors that you have to somehow hoard together. So I don't know. We will ask our two speakers to explain the gravity of writing a monograph or an edited volume, respectively. But essentially, why are we touching on the question of abuse or just use of national constitutional identity in the pluralist European Union? It is a phenomenon that emerged by way of the Treaty of Lisbon, whereby, as juxtaposing to the primacy of EU law, there was this clause that also national constitutional identities ought to be protected or safeguarded. Some scholars at the time thought this was just a truism, something that is characteristic of any federal system, but it soon turned out that this truism, especially when things go astray, when we have cases and examples of systemic defiance, both of the rule of law, democracy, and fundamental values, this national constitutional identity might work pretty much at the detriment of European integration. And having read, or at least explored, the two books, I'm very happy that it's not me who's going to present them, but our two speakers. So just basically to go to the heart of our debate, and saying also to our audience that you can also chime in by typing your questions in our chat. I would like to start with you, Kriszta, and then the same question, the same first question will also go to Julian. And the question is, why did you think it was important to edit or to write this book, respectively? Kriszta, what would you say?
Thank you so much. I'm very grateful for the opportunity to talk about the book I edited and co-authored. And I also prepared some slides. So let me share my slides with you. Do you see?
Yes, we can see them.
Okay, sure. So that's the book. This is how it looks like. And as you said, I edited and co-authored this book. And first, I plan to write a monograph, because this is an outcome of a Marie Curie research fellowship. But then came COVID and travel was impossible. So I could not travel to the respective courts. So I asked experts to do the job for me. So that's why I edited and co-authored this book. And I chose this cover because I think it is abstract enough and still conveys the message that the EU member states are different in various ways. They embody different values and have different constitutional structures and institutions. Yet there is something that connect or should connect all these states, and these are the so-called underlying constitutional principles. And if they concentrate on these principles, a strong supranational entity can emerge above and over the states. And this supranational entity recognizes the national identity of the member states. So the national flags are still visible in the court, as you can see, and they constitute an essential part of the European project. Yet this project can only be strong if it becomes a court, a bond of constitutional principles. And that's what we can see on the back cover. But of course, that's only my interpretation, and the interpretations can vary from reader to reader. And you might also notice on the cover that there is an open access sign. This is because it is an open access book. So basically, you don't have to buy it to read it. You can upload it from the publisher's website. And this is a good thing. And as I said, it is an edited volume. I hope you can see the slide, which means that the collection brings together some of the leading international experts on constitutional theory and identity, such as Susanna Beer, Matthias Kumm, Gary Jacobson. Other contributors are early career scholars like Max Steuer, Katarina Shipulova, or Michal Tsiolkovsky. And there are two authors in between, Monika Polzin and myself. And what is also interesting is that all of the authors, except for Matthias Kumm and Gary Jacobson, worked as judges or counselors or advisors at their own national constitutional courts in the past. So they have practitioner experience, and they bring this unique insight into the project. So why was it important to co-write and edit this book? Well, because I wanted to understand the debate on the scope of identity that was going on between member states and the EU. And I wanted to work on a solution. The book has, as I see it, three key novel aspects. The first one is the geographical focus, which is the so-called Visegrad countries, Czechia, Hungary, Poland, and Slovakia. Why exactly those countries? Because these countries have recently rediscovered their national identity in common ancestry and shared ethno-cultural heritage. And I'm not saying that this phenomenon is limited to this region, but I think that this region has recently exhibited the most visible signs of exclusionary nationalism in the EU. Of course, this exclusionary nationalism is not new either, but what is new is that these countries have cited Article 4, subsection 2 of the Treaty on the European Union as grounds for limiting the authority of EU law. Just a couple of examples. In 2015, Hungary and Slovakia used this concept, the concept of national identity, to reject the EU refugee relocation scheme. Later, these countries argued, or the government argued, that the traditional family is a value protected as an element of national identity in EU law. So the EU should allow these countries to avoid recognizing same-sex marriage. Or Poland invoked Article 4, subsection 2, when it, let's put it this way, reorganized the judicial system. Interestingly, the Visegrad Group was established in the early 1990s, to achieve Council of Europe and EU membership. So in that sense, the mission is accomplished. And it was interesting to see what the goals of this group right now. And of course, today, these countries are not the only ones that use Article 4.2, subsection 2 as an excuse. As Radosveta Vasiljeva mentioned in her book review, Bulgaria later followed suit. But when the book was written, these 4 countries were eminent in this respect. Okay. What's the other 2 novel aspect? The second one is that the book uses the concept of particularism. So it examines the judicial identity claims, so the identity claims of the Visegrad 4 countries, judicial bodies through the lens of particularism. What is it? Well, the starting point of the book is that there are universally valid constitutional principles, but these are abstract, like human dignity or equality or freedom. So they need to be interpreted. They need to be adopted in the domestic constitutional context. So basically, the book calls this domestic manifestations or the reflection of the universal ideas as particularism. And the exercise of the domestic courts, the jurisprudence of particularism. And the book differentiates between 2 types of jurisprudence of particularism. One which corresponds to universal values. For instance, the human dignity can be interpreted in a way that hate speech is a crime. This is the case, for instance, in Germany, but it can also interpret in a way that allows to challenge even the most important assumption of constitutional democracy, that people's lives are equally important. That's the US jurisprudence, and also that's what the Hungarian jurisprudence followed after the democratic transition in 1989. I see something in the chat, is it? Okay, it's not for me. So in this case, the jurisprudence of particularism corresponds to universal values. And this type of jurisprudence also uses the language of identity, but it applies the concept of constitutional identity, and it understands it in a political constitutionalist sense. The other variant, let's put it this way, is the jurisprudence of particularism that does not correspond to constitutional principles, because the interpretation is informed by ethnocultural considerations or historical myth. And the book says or argues that the Visegrad countries' constitutional courts or apex courts tend to provide cultural, historical explanations of constitutional provisions. And that's a problem because this is inconsistent with the foundational values of the European Union, first and foremost, the equal human dignity. So the third novel aspect is the question the book asks, which is what can be the constitutional challenge? So basically it searches for a principle-based tool for a constitutional challenge to these judicial invocations. So what can the ECJ do? We all know that in the EU law, the concept of national identity is a legal concept with constitutional meaning. So when I talk about national identity, in this case, it is constitutional identity. And the book also shows that the ECJ case law already acknowledges that that this type of identity is connected to an independent and democratic state. And the book argues that from here, it would take only a small step to recognize that national identity is an autonomous concept, and that the court should use the proportionality review with a strict scrutiny test. I think we can talk about it later. Let me finish by saying that the main idea is that constitutional identity cannot be divorced from constitutionalist principles because its point is to protect constitutionalism itself. Thank you.
Thank you very much, Kriszta, for this succinct but very rich presentation of the book, for the reasons for writing it, and also its most important messages. We'll certainly get back to that. But Julian, you have been listening now to Kriszta. She has pushed the discussion already pretty deep. So the floor is yours. The same. Why did you decide to pick this particular angle? I do know that this was part of your PhD project, but which matured much more than that. So reveal us the reasons behind it, and maybe also already the most important findings of your book. And unmute yourself, otherwise we cannot hear you. Sorry.
Yeah, I'll briefly introduce the book. Thank you so much for inviting me to present the book, Matej. So my book, I have it here. It's called The Abuse of Constitutional, I think, wait, I have to unblur my background in order for it to actually show. It's called The Abuse of Constitutional Identity in the European Union. It was recently published. Here's the book. It was recently published with Oxford University Press. It came out in September of last year. And as you said, this book is based on my PhD project, and what lies behind it is essentially a very simple question, and that is there a way in which we can tell different arguments from constitutional identity apart as for whether they are or they should be considered legitimate or abusive, right? And the backdrop to this, Kriszta has already explained some of it, right? So Article 4.2 of TEU gives special recognition to this idea of national identity. And by extension, a notion of constitutional identity, and this has led some of the national constitutional courts, actually quite a few of them, to develop doctrines of national constitutional identity as a limit to the primacy of EU law. Right? We see this most prominently in Germany, but then if we look through the case law, we see it in Spain, in Czechia, in Poland, in Hungary, in France, in Belgium, in many countries. Can we see such doctrines of constitutional identity, right? And the big controversy that this book tries to tackle, which is also very closely related to, I think, the challenges that Kriszta's edited collection tries to tackle, is how can we determine whether what is claimed as constitutional identity is legitimate or abusive, and can we find a way to more clearly delimit what can be legitimately claimed as constitutional identity, in particular because this idea of constitutional identity has come under attack by a lot of people. It's seen as by nature allowing the assertion of sort of national parochialisms, of nationalistic particularisms over the primacy and the legal rationality of EU law. Right? We saw this in Hungary with the question of the refugee relocation scheme, where the Hungarian government, in concert with the constitutional courts, used this concept of constitutional identity in order to set limits to the primacy of EU law. on and invoking and basically an ethnically homogeneous concept of the Hungarian nation. We saw it in Poland, where the Polish government, again in concert with the Constitutional Court, used the idea of constitutional identity to push back against the ECJ's rule of law jurisprudence. And so against this backdrop, the book tries to effectively defend the idea of constitutional identity to some extent by developing an idea of, or by developing a conceptual frame for the idea of the abuse of constitutional identity. Oh, sorry. And so the way the book goes about this is primarily theoretical, right? So this is not a doctrinal book. This is not a book about how to interpret Article 4.2 of TEU. It's a book that tries to take the idea of constitutional identity and what constitutional identity tries to invoke seriously in theoretical terms, and tries to work its way through that idea on those theoretical terms, right? And I effectively try to develop a conceptual framework that through which we can examine and scrutinize this idea of constitutional identity. And the core part of the book consists of 3 chapters, which goes through 3 different dimensions of constitutional identity abuse. And those 3 dimensions I label generative, substantive, and relational. And I'll briefly explain what I mean by each of these dimensions and what each of these dimensions covers, right? So in the generative dimension, I effectively ask, how has a constitutional identity claim come about, right? So I inquire into the relationship between constitutional identity claims and constituent power, constitution making, constitutional change, amongst other things. I dig a bit deeper into sort of this traditional understanding of constitutional identity as resting on constitutional unamendability and eternity clauses, as we see, for instance, in the jurisprudence of the German Constitutional Court quite prominently. And I question that understanding actually quite critically. I think there are some issues with this idea of constitutional identity as being grounded in unamendability or tied to unamendability. I look at the politics of constitutional amendment that are tied to constitutional identity, because one of the things that we've seen, especially with Hungary, was an increasing tendency to actually instrumentally amend the constitution, specifically with a view of generating certain constitutional identity claims. Right, we saw this with reference to refugee policy, where specifically the words constitutional identity were amended into the constitution. We saw it with respect to family and gender, with I think it was the 9th Amendment of the Hungarian Constitution, where again, I think the Constitution was amended to include the right of children to be educated or raised in accordance with Hungary's constitutional identity. And so I question the logic behind that practice, right? Can you really amend something like constitutional identity on a day-by-day basis? And what does that mean for the concept of constitutional identity? And so one of the core arguments that I advance in the chapter is that if constitutional identity becomes something that can just be amended on an instrumental basis, then effectively becomes a meaningless concept. It becomes not really distinguishable from ordinary politics in any meaningful way. So that is the generative dimension, very briefly, right? Then in the substantive dimension, I effectively ask, what does a constitutional identity claim entail? It goes really into the question of what is the relationship between constitutional identity and a deeper concept of constitutionalism, right? Just as Kriszta also mentioned, right? It's very much the same argument that I pursue here, in that I argue that constitutional identity claims have to be tethered to some kind of shared notion of constitutionalism. They have to be seen as a particular way of I see Kriszta agrees.
What happened?
I think
So
we're
sorry.
just celebrating consensus among the two of you.
Oh, okay. Good to know.
So constitutional identity has to be seen as speaking to a particular way in which a polity enables itself to exist under conditions of constitutionalism, rather than, and this is what sort of these illiberal varieties of constitutional identity tend to do, they flip this whole idea around. They see identity as the things and the terms that very much define what is constitutional to begin with, right? Where constitutionalism is something that arises out of identity rather than identity being something that has to be somehow integrated into constitutionalism in some kind of way. And so with that in mind, I examine sort of these thicker notions of identity as ethnocultural, religious, as we see in Hungary, where this strong sense of social and ethnic homogeneity is being mobilized, for instance, to resist the relocation of refugees. And I ask, can this really be seen as compatible with any kind of idea of constitutionalism when we really dig deep into the underlying assumptions of that? And I end up concluding that we really cannot see this as compatible with a thin or a thick notion of constitutionalism in any meaningful way. Yeah, and then finally I go into the relational dimension, which effectively in that dimension I ask, how are constitutional identity claims advanced, right? So that chapter speaks to sort of this traditional EU law scholarship on judicial dialogue, on constitutional pluralism, on those sorts of things. And the argument that I make in that chapter is that we cannot just look at constitutional identity claims on their own terms, but we also have to take into account and in terms of their legitimacy, how such claims are advanced, right? How constitutional identity claims are advanced is inevitably tied up with their legitimacy. You cannot just advance a constitutional identity claim in order to completely disengage from overlapping constitutional authorities like the EU. Constitutional identity claims always need to be the start of some kind of dialogue rather than the end of a dialogue. Precisely because, and this links back to the question of, is constitutional identity really that closely related to eternity clauses, to this, this final moment when a constitution ceases to be one thing and starts being another thing? Or is it really something more contingent, something that's capable of changing within the polity? And if that is the case, then we have to be able to negotiate. We have to be able to compromise, to mediate in some kind of way around questions of constitutional identity. And that's where the importance of judicial dialogue ultimately comes in. And through that lens, I then again critically examine, for instance, what we've seen in Poland and in Hungary, where precisely sort of constitutional identity was mobilized both by governments and constitutional courts in tandem. I think the one differentiating mark, say, between what we've seen in Germany with the idea of constitutional identity and what we've seen in those two countries is precisely that in Poland and in Hungary, there was a back and forth between the government and the constitutional courts about how to most powerfully leverage that idea in order to resist EU law. Whereas in Germany, it was really a matter of, it is mostly a matter of dialogue between the Constitutional Court and the Court of Justice. Some small exceptions like the PSPP case perhaps aside, where it became a bit more contentious. But ultimately, it was always seen within the frame of a dialogue, right? And so through these three lenses, I try to come up with a sort of theoretical frame through which we can discuss the legitimacy of constitutional identity claims. And that's ultimately the main project of the book. And I'll stop there for now.
Thank you, Julian. Having listened closely to you and to Kriszta, it's become clear that on the one hand, constitutional identity is not something which is a priori set in stone. On the other hand, it's not also at the same time, it's not something that can be easily amendable and instrumentalized for political purposes. And it seems that in order to be discoverable, in order to discover it, there has to be some sort of contestations between different legal system, because in many ways, until the questions about constitutional identity are raised, this constitutional identity might be just go, unassumed, or actually assumed, but without being actually verbalized, being made explicit. But I would like to draw both of you now to the title of our today's talk. And this title, in a way, invites the question of how to draw, and both of you are already pointing in that direction, but I would like to push you to be more explicit, how to draw this fine line between the cases of where one can say, well, this was a legitimate use of the argument of the national constitutional identity against those other arguments where one could say, well, this was the abuse of the national constitutional identity. And most importantly, in such a, even if I don't use the word pluralist, but if I use the composite, right? In a composite system, such as the European Union, where you have the national level and supranational level, who is to say, who is to pronounce eventually on the legitimacy or illegitimacy of the use of the national constitutional identity? Kriszta, maybe I would like to invite you here first, and then Julian will also kick in. Please, how would you try to respond to this question?
I have so many things to say. I don't know where to start. You mentioned that identity is not set in stone, and I really agree. So communal identity is not something given. It is a socially constructed concept, and political actors construct and apply this. And this can take the form of national and constitutional identity. So I would differentiate between the two, because I think that traditionally constructing a national identity is the pre-legal ethno-cultural understanding of this notion. But in a democracy, this understanding has been restricted by the universal constitutional principles. And with this restriction, the understanding of national identity has evolved from a pre-legal to a legal. And I say that this is important because in my view, when Julian just mentioned the Polish or the Hungarian court, when they argue, they don't, or their governments, the previous government, they don't use the constitutional identity, but they use this pre-legal national identity. And I think within the EU, it is for the European Court of Justice to decide whether this national identity claim is valid or not. As a matter of EU law, right? And they can, whether it can justify derogations from EU law. And during this exercise, the ECJ should decide whether it interprets the term national identity in light of the constitutional structure of every member state, or it uses this term as an autonomous term. And I argue that the court should use this term as an autonomous term and interpret this as an autonomous term. And Julian mentioned that there are various ideas on constitutional identity as a legal concept within the scholarly literature. You mentioned that some question the conceptual value of constitutional identity and call for abolishment, and they call it a dangerous concept. Andrea Chaillot, Federico Fabrini, Laurent Pesch, and I can continue the list. But I think we both agree that the rejection is likely to be unsuccessful, given the central role of this term and this is the question I've always wanted to ask you, because I think that there are scholars who say that constitutional identity is a legitimate concept, but abuse can happen. So they understand constitutional identity as a descriptive analytical tool. I think this is the way how Gary Jacobson sees this, or Jacqueline Neo. But in this view, even those constitutions that don't correspond to constitutional principles have constitutional identity, like China, Russia, or Hungary. And that's why the book offers a third view, and it says that it's a legitimate concept, but constitutional identity can only be attached to a democratic constitution. So the constitutional identity is the identity of the constitution, and only a democratic constitution has a constitutional identity. So in this view, the constitutional identity as a socially constructed normative concept, and it is rooted in the text, of course, but it emerges from the dialogical process of democratic institutions. So there are different ideas, and I always thought that maybe Julian is closer to the second one, that it is a descriptive analytical tool, than the third one.
That's very interesting. I think also very helpful also for our audience. So first of all, what you're saying, it's not just semantics that matters, but semantics matters as well. But what is behind the semantics is also there are conceptual differences. So you are saying that first of all, we should distinguish between the national identity claims, which are in a sense pre-political, and that might be later on constitutionalized as part of the constitutional identity. But in order to be entitled to the constitutional identity claim, you have to pursue a particular type of constitutionalism, which is a democratic type of constitutionalism, or a kind of constitutionalism which is prone to universalizable arguments. Julian, what do you make of those distinctions? And as Kriszta has invited you, where do you stand in terms of the descriptive, analytical, or I know that you're not in the camp that would reject a priori the very existence of the constitutional identity, but could you also see it as something which is useful for the European project? So it doesn't have just an analytical and descriptive value, but it might also have a positive normative value in and of itself that of course could be abused, but still.
Yeah, it's a really interesting question, and one that I've been thinking a lot about, especially as Gary Jacobson will be commenting on my book at the ICON conference in Madrid, and he will probably definitely bring this kind of argument up in our discussion. Maybe to start with the question of where do I stand on whether constitutional identity is a positive or a negative thing. I mean, I think it's just like Kriszta said, it's something that we have to deal with. It's something that we have to reckon with. My colleague Božko Tripković describes constitutional identity as something that's inescapable, something that we simply cannot get around it, because there will always be particularities attached to the ways in which a polity enables itself to exist under conditions of constitutionalism, right? So that's something that we simply have to reckon with, right? That's and that doesn't mean that it's always a good thing that constitutional identity exists as, you know, a normative concept that can be invoked, because it can also be abused. But at the same time, I don't think we would be well placed to simply dismiss that concept or simply describe it as something that is dangerous and should be pushed aside, because if we look specifically at the EU context, I think the EU's legitimacy is deeply wound up with not interfering with those particular ways in which different countries have enabled constitutionalism for themselves. You know, the tricky compromises, the strange contingencies, and so on, that we find in all countries that cannot simply be rationalized away. And if there is a conflict between EU law and some of these things, this conflict has to be taken seriously, and cannot be simply and should not be simply brushed aside with a reference to the primacy of EU law. But I think that the question that Kriszta asked me was probably a slightly different one, and that is how can we actually make sense of constitutional identity conceptually? What kind of a concept is it? Is it a concept through which we can describe the ways in which certain constitutions exist and evolve in an analytical, descriptive sense, or is it a normative argument that has a normative weight attached to it, that commands respect and recognition from other parties that we might be involved with, right? And it's a tricky question, and I think we have to be able to see both dimensions of that concept in some way, right? I think the criticism that Gary Jacobson advances of these, say, more normative ideas of constitutional identity is that we foreclose ourselves of distinct ways of understanding also illiberal and non-democratic constitutions if we say constitutional identity is only something that attaches to liberal constitutions. And I see that argument because even illiberal constitutions speak the language of constitutionalism. And it's precisely those ambiguities and those paradoxes where the idea of constitutional identity paradoxically might provide inroads towards a more liberal constitutionalism, even in those illiberal constitutions. And I think that is the argument that Gary Jacobson would make. But I think that has relatively little bearing on the way in which we talk about constitutional identity in the EU concept, which I think is a very distinct and different way of making sense of the concept. And that, I think, ultimately is best understood as a normative argument, right? It's a way of saying we have these certain constitutional particularities that have simply evolved in this way within our polity that demand normative recognition because they speak to the particular way in which we have framed ourselves as a constitutional polity, right? And as such, an argument, it's intrinsically tethered to a stronger normative sense of constitutionalism. So my response would probably be we shouldn't dismiss the idea of constitutional identity as something that has a descriptive and an analytical dimension, but I think within the concrete EU context, it takes on a distinctly normative dimension. Yeah.
But what have you just said, wouldn't that mean that your understanding of constitutional identity and the very reasons for its existence would bring you into that camp that Kriszta would call the arguments based on national particularism, that couldn't be justified from the sense of the constitutionalism that rests and is based on universalized or universal values?
Well, I don't think there is such a thing as universal constitutionalism. I think there are normative ideals that we all share and that we all try to stick to and to accomplish, right? But the concrete ways in which we realize those ideals is always particular because the societies that try to realize them for themselves are always particular societies that have different kinds of history, different kinds of baggage, and that simply needs to be reckoned with, right? So what I would reject is, say, this more is, say, a strictly liberal and a strictly, let's say, optimizing concept of constitutional identity, right? That simply sees constitutional identity as an expression of universal values that can be measured against each other, and where we can ultimately find the best conception of that value. And then constitutional identity is something that ultimately fades into the background eventually. Precisely because I don't think that is very feasible, given how different societies are across different countries.
Kriszta, what would you say to that?
Yeah. I understand when Julian says that there is no such thing as universal constitutionalism, and I'm not saying that there is, but what I'm saying is that there are universal constitutional principles, and these principles, like democracy, the rule of law, protection of human rights, should guide the political communities once this political community wants to be the community of free and equals. So these are the principles, and these are valid all around the world. So that's why they are universal. And you mentioned that even illiberal systems use the language of identity, and also they use the language of constitutionalism. I mean, they argue that their democracy is the best, the more developed democracy. They use the language of the rule of law. They use the language of identity also. But that doesn't mean that we should accept that. And I think that we should clearly show that what is happening here is that they try to pretend that they are democracies, and even better democracies than liberal democracies. Or they see these unliberal or illiberal democracies or anti-liberal democracies as something that is better than what we call as liberal democracy or constitutional democracy. And in this book, I wanted to show that what they do is basically to use this pre-legal national identity and call it constitutional identity. So I don't use the word abuse because I'm not in, I'm not with you in this, but I understand what you mean when you talk about abuse.
Julian, would you like to respond?
Yeah, I think we're actually in agreement on sort of the bulk of the question here, in terms of if we take constitutional identity to be that normative concept that, you know, demands some sense of recognition, that demands respect from other constitutional orders, then it has to be seen as a concept tethered to normative criteria, tethered to these universal ideals of constitutionalism. There, I think we're fully in agreement. It's just a question of how can we still, in terms of, you know, legal scholarship, make space for more analytical, descriptive conceptions of constitutional identity that may be useful in certain ways, as a way of describing and understanding constitutions. I think that's the crux of the question when we think about it conceptually.
Right. There are two things that might be disturbing, right? On the one hand, if you really buy into, if you say that constitutional identity is a property of any kind of regime that calls itself constitutional, then you might, I think Kriszta would be pointing her finger at that, be traveling the road down to relativism, right? Chipping away the very essence of what constitutionalism properly so called, if there is such a thing. And once it comes under attack, maybe there might not be such a thing. So there is this thing, the danger of relativism, right? If you allow too much scope to the constitutional identity. But at the same time, there might be also no scope allowed to it, especially if you travel more down the Kriszta's road, and as Kriszta has responded to my question, so who is to determine the scope of the constitutional identity of the member states? And you played with an idea, Kriszta, that of course and rightly so, if this is a concept, if it's a notion in the treaty, it's an EU notion, it has its own autonomous meaning conferred upon by the Court of Justice of the European Union, which is all fine, but conceptually and theoretically, but there is some sort of maybe not just a practical, maybe a bigger political problem, which sounds like this. So what is left? What kind of an identity? What kind of an identity of a member state is if its boundaries are only to be determined externally by another actor sitting in a different legal order? So you see what I'm saying? Is it possible to confer the right on determining on the boundaries of your constitutional identity to an actor which sits in a different legal order? Is this still a national constitutional identity?
Me first? Or Julian?
Yeah, it can be you, if you want.
Okay, it's a tough question. And I think that it's a question of authority, and within the EU, the ECJ is in the position to decide whether a national identity claim is valid as a matter of EU law. And I also argue that the ECJ case law already encompasses very important elements. It says that the concept of national identity is a legal claim, and also that the court connects it to the democratic and independent and state. This is what we see in the Sein-Wittgenstein, the Bogendorf, Runjevich-Vardin, and other cases. And what I argue is that that the ECJ should also recognize that that it is only the democratic constitution that has a constitutional identity, and the EU law should respect only this type of constitutional identity, and this is because only a constitution perceived as a higher regulatory norm can establish legitimate authority, which is tied to the protection of human rights, democracy, and the rule of law. And you asked me about the interesting thing that the European Court of Justice is somewhere outside, which I don't think it is somewhere outside. I mean, EU law is also a national law. It's within our domestic legal system, first. And second, in this case, the ECJ doesn't do, what it does do is to say that, look, you should live, look, member state, you should live up to the ideals, to the principles you already subscribe to. So it's not something, it's not external, it's just a reminder that you already corresponded to the constitutional principles, and you just have to follow these principles. And if you are not subscribed to these principles anymore, then there are ways out, right? Julian?
Indeed.
Thank
you. I mean, and apologies for hard questions. We are coming to a close, and there have to be also hard questions. Kidding. Julian.
Yeah, my thinking on this question is perhaps a bit more well, not as clear cut in terms of I'm quite ambivalent about the role that the Court of Justice and the role that Article 4 Section 2 really plays in terms of the politics of constitutional identity. Because I think ultimately what we are dealing with when we're talking about these big disputes of constitutional identity is we're talking about conflict between different constitutional orders, right? And so obviously I agree that the ECJ should develop an idea of what the limits of Article 4 are, and should try and provide an understanding of how far that article accommodates different identity claims. But I don't think that that necessarily settles the question. I think that there will always be scope for interconstitutional conflict because the national constitutional courts will always be able to say, well, we're simply interpreting our constitution and acting on what our constitution demands from us. So I don't think these conflicts can be quite easily subsumed within the scope of the treaty. And also, the question then becomes, can we really always trust the European Court of Justice? And perhaps I'm slightly controversial here, but I would think that with its evolving value jurisprudence, right, around Article 2 and so on, the court is increasingly getting into highly contentious territory, right, into territory where the potential for it to provoke some kind of strong conflict is increasing now. And so the question becomes, can we really just subsume those questions under Article 4, or is there ultimately a wider conflict at play that we also have to take into account and that we also have to deal with? So in that respect, I perhaps are more on the say the constitutional pluralist side, in the sense of Neil Walker, for instance, taking a more sort of epistemic, perhaps even radical understanding of pluralism as at the basis of what drives these conflicts, right? So if they can be accommodated and if they can be settled within the scope of Article 4, then that is great. But I don't think it is necessarily always the only option or the only plausible outcome. And for that sake, I don't necessarily think that it would always be an abuse for a national court to set aside the primacy of EU law in those kinds of conflicts. I think there can be certain areas in which that can be legitimate. But obviously subject to very strict criteria of legitimacy that I try to unravel in the book to some extent. Yeah.
Thank you. Thank you. Of course, the letter statement, I mean, invites a whole new discussion for which we unfortunately do not have time anymore. But there will be an opportunity for sure, or if not, we'll take one. Right? We'll seize one to debate these issues further. I wanted to end on a positive note, and that is to ask you if there has also something good come out of it, of this jurisprudence of constitutional identity. Because, you know, this debate has always been underlined by criticism, or at least with concerns. But has it in your mind also, in terms of the overall holistic soundness of the constitutional system of the European Union, has this debate, has this contestation between national and supranational legal order also brought about any positive developments? Maybe Julian first, and Kriszta will have, of course, the last word.
It's a difficult question. I think the language of constitutional identity on a lot of instances has increased the accountability of the Court of Justice also to some extent, right? If we think of the European arrest warrant cases that very strongly involved the language of constitutional identity, both in Germany and in Poland, I think there it actually led to, you know, a strengthening of the protection of rights. And in that sense, it can be, those conflicts can be seen as something very, very positive, right? And I also think ultimately, just being aware of the relevance of constitutional identity and paying heed to these conflicts is ultimately something that can only strengthen the legitimacy of the EU, right? The more those things are taken seriously, the more there's serious dialogue about these things, the stronger the EU will get, despite all of these abuses, right? Because ultimately the fundament of the EU's legitimacy still is the acceptance and the cooperation of the member states. So in that sense, being aware of the precarious fundament of the EU's legitimacy and the way in which it is tied up with the idea of constitutional identity can in itself be seen as a maybe somewhat timidly can be seen as a positive in a way. Yeah.
Actually, I see the concept of constitutional identity together with the concept of the basic structure doctrine, or the eternity clauses, or the unamendable constitutional provisions. So these are all concepts that protect constitutionalism. So that's their point, to protect constitutionalism. And in this sense, it can be seen as something positive. And I see Julian's point, and in a way, I think he can agree with Dieter Grimm, who says that this ongoing constitutionalization of the EU treaties may decrease EU legitimacy. But I'm thinking about the importance of upholding the fundamental values, and I think that it is good if the ECG is empowered to uphold these values. Otherwise, we cannot prevent the EU from reverting to an economic alliance of isolated sovereignist states with their own agendas. So this is the danger that I see, and the book offered one possibility of how the ECG can best ensure that these values are upheld.
Thank you very much also to you, Kriszta. It was highly enjoyable to talk to both of you, to listen to both of you. We haven't exhausted the debate. There's so much so that can be still said. Those who would like to delve deeper, of course, they should go and read your very interesting books. And on a positive note, as any exchange between different people, different individuals, or for different societies, and also these identity claims in the EU, they have also in a way forced the Court of Justice of the European Union to spell out clearly what the identity of the EU is, right? What is the constitutional identity of the EU, and that's Article 2. I think that was an important achievement, but of course, at the same time, this also can suck the court into all other controversies that might still arise. But this debate will be continued. We have to finish here once again by thanking you for being with us. This event today has been recorded, and those who have missed it will be able to watch it many times on YouTube channel of the New University. Thank you very much, and
Thank
see
you
you
so much.
soon.